All right, I promise you the reason that we're here on the first session ain't because we're going to go long, okay? I want to get out of here just as fast as you do. The title of my talk is Memorable Events and Experiences and Lessons Learned Over Nearly 50 Years. That's my title. David Allen's title is 20 Years a Lawyer, 30 Years Worth of Bullshit. I thought that I ought to purge myself of these experiences and lessons learned before I started drooling and crapping in my pants. And that's how come I'm here today, because I'm getting damn close. I had the privilege of handling cases in 85 of North Carolina's 100 counties and trying over 300 cases to jury verdict. And you can't have that privilege if you don't have great mentors. And I had a couple. John Anderson, who was described as not having ulcers but a carrier, was one of mine, and he was a fabulous, fabulous lawyer. And he always emphasized knowing the rules of civil procedure. And he'd rather win a damn case on a technicality than on the merits. And he was really good at it. Jim Blunt, another one of my mentors, was all about instinct and taught me to trust your judgment. And he would show up in your office and say, how you fix next week? Which meant you were going to try a case next week that you didn't know a damn thing about. And but he was all about trusting your judgment. And another aspect of it is you got to have a great support system. And I certainly have had that. Great staff. I've had a secretary that's been with me since 1971. I've had great colleagues. Some of them are here today. And I've had great clients. Back in the 70s, we represented St. Paul. And then in 1975, St. Paul had, they decided that there was an insurance crisis and they were going to pull out of the insurance market. And that led our good client, the North Carolina Medical Society, to hire us to form a new insurance company to insure doctors, and that's how Medical Mutual came to be. And we represented Medical Mutual exclusively around the state for about 12 years. And they hired a claims manager named Wayne Parker, who decided that med mal cases ought to be handled like automobile wreck cases, and we parted ways. We then picked up the Scott Group. Steve Scott was an OBGYN that started emergency medical services, coastal emergency services, and a insurance company, Century American, and that took us all around the state. And then Mag Mutual came along at the end of the 90s, and we've been with them ever since. Some memorable experiences. As a young lawyer, I came in from depositions one day and got a, some of y'all will remember, used to get pink slips, phone message. And an OBGYN from Reedsville named Don Martin had called. And it was late afternoon, and I said, hell, I'll call him in the morning. The next morning, I called back and learned that Dr. Martin had been sued and had committed suicide that night. And I'll tell you, God damn it, I return phone calls as fast as I can. And that's a tragic way to learn the lesson, but I learned it as a young lawyer. Another lesson learned involved the Burroughs Welcome case. The skin of the building was coming off when it rained. So we sued everybody in sight on behalf of Burroughs Wellcome. We had everybody in the defense bar in our part of the world in that case, and we were on, Jim Blunt and myself were on the plaintiff's side. And after about 2.5 weeks of trial, we got the first $1 million settlement that any of us knew about in North Carolina. And we took all of the defense lawyers, all of the clients, all of the parties, the Judge Dupree and Judge Dupree's clerks, which included Jim Gale at the time, and we had a Bloody Mary brunch at the Carolina Country Club. And the lesson from that was collegiality and trying to enjoy the experience. Jim and I represented Argonaut Insurance Company. And Argonaut was located in Palo Alto, California. And they flew Jim and myself out there about once a month, first class. And Jim and I had to reach a pact. And the pact was that we would continue to represent Argonaut until they became insolvent or one of us developed cirrhosis of the liver, whichever occurred first. The lesson there is have as much damn fun as you possibly can. We represented the N&O in a social host liability case. One of their employees had gone to a party at Frank Daniels' home. Frank Daniels was a publisher of the N&O, and Frank was a master host. I mean, nobody's ever given parties like Frank and Julia Daniels. Well, they got sued because one of the employees of the N&O left the party and had a wreck out by the Angus barn and killed a fellow that had a wife and 2 kids. And the only expert for the estate was a fellow in San Francisco. So I went out to take his deposition. And it turns out he was an expert, so-called expert in social host liability. He was a goddamn bouncer in a strip club. And he's trying to tell Frank Daniels how many damn ounces of alcohol to put in a drink. And so I'm just gnawing his ass. And the son of a bitch pulls out a pistol and puts it down, pointed at me. And I didn't miss a question. I took the damn thing and turned it around facing him and just kept right on gnawing. I think the lesson is don't be intimidated. The grandest case involved a lady that had been administered medication while at Duke, and she was in a coma. As a result of the administration, she was in a coma and paralyzed her lungs and caused her to be brain damaged. And there was a tremendous lawsuit about it, and we kept digging and we kept digging and we kept digging. And damn if we didn't learn the medical truth of the case was that her husband was a CRNA who worked 2 floors up from where she was in the hospital when she got the medication, and he had tried to kill her with Pavulon and had paralyzed her lungs. And obviously that case went away very, very quickly once we were able to establish that. But the lesson there is be persistent, keep digging, and keep working towards the medical truth. I want to talk to you real quickly about opportunities and trying to take advantage of them. I was representing an orthopedic surgeon, and we were in the middle of trial, and the deputy sheriff comes flying in the courtroom and says, a juror next door is having a seizure, and I heard there's a doctor in here. And my doc turns to me and I said, don't come back unless you got blood on you. Seize the opportunity, folks. I was representing a family practice doc and a juror passed out during the trial, and he looked at me in sort of a panic, you know, what do I do? And I said, get in the damn jury box right now. Of course, there's no judge that's going to say, don't go save the juror's life, because it might cause us to have to mistry the case. And he revived the juror, took care of the juror, came and sat back down, and we continued with the trial, and the jury did exactly what you think they would do. I defended a North Korean American named Dr. John. And Dr. John, during the middle of his trial in federal court, they had a naturalization procedure. Have any of you ever been to a naturalization procedure? It is all about the flag and patriotism and American way, and it's just a wonderful thing, makes you feel good. And our jury's sitting there watching the damn naturalization proceeding. And of course, my doc had been naturalized. So I threw out my whole game plan, and my closing argument became apple pie and America and motherhood. And I knew I was getting there when I looked over and the court reporter had tears coming around her mask. The Bauer-Schmidt case involved a little girl that had meningococcemia and lost 4 extremities. It was a terrible case, and Bill Thorpe represented the plaintiff. And Bill was a great lawyer, but he could be a pious, sanctimonious ass. And we had a deposition of my client, and he was just giving my client hell. And I declared a break, and we had a whole room full of lawyers. And I was slow getting back in because I was trying to pump up my doc and give him some courage. And all of a sudden, a goddamn clown shows up out in the hall, and his office is in the building we're in, and he's been to a kid's birthday party. He's got his clown outfit on, he's got damn balloons. And I said, how much would you charge me to go in there? And I pointed out Bill Thorpe. I want you to hug him around the neck and tie a damn balloon on his chair. He said, I'll do that for free. He did, and Bill Thorpe got so goddamn flustered, he just completely lost it. I mean, here's a damn balloon on his chair, the damn clown is hugging him. He left a lot on the table that day. Now I'm going to talk to you about some bad outcomes. I'm bearing my soul, folks. This ain't about all good stuff. The Ruark case involved the birth of a stillborn, and we got it dismissed on a motion to dismiss. It went to the Court of Appeals, and they reversed it. And I turned to my partner, Bill Moss, and I said, hell, it can't get any worse. Let's take it to the Supreme Court. Well, goddamn, it got a lot worse, y'all. I made up the negligent infliction of emotional distress claim right there. The Adkins case involved the infamous wink. Had an OBGYN on the stand, and the lawyer for the plaintiff was Steve Milliken from New York City. He's pretty damn good. And during his examination he called my guy as an adverse witness, and during his examination, he stopped me. He said, "Did you just wink at the jury?" And of course, I went ballistic, and I obviously that didn't happen. Let me voir dire my own client. And I got him to turn and look at the jury and say, I said, "Did you wink at the jury?" He said, "No." Well, I learned later that the damn guy had a neurologic tic that when he got nervous, he winked his damn eye. And he didn't know about it because his wife didn't want to embarrass him. That wink cost me $6 million. The jury never believed another damn word he said. The Hux Follis case involved a fellow who had done, he was a neurosurgeon and he'd done surgery on a fellow's back. And the plaintiff's complaint was he didn't use loops, which magnifies. And when he's on the stand, Joe McLeod gave him a document to read, and the dumb son of a bitch kept doing this like he couldn't read the damn document. That cost me a lot of money. Now I want to change to a more pleasant subject, like likability and your client being likable. Burt Walls was OBGYN from Fayetteville who had just the greatest smile you've ever seen. He was a really, really good guy. And the case involved twin transfusion and intrauterine growth restriction. And the plaintiff's experts had just beat him to death with all that. And so I had him up on the stand and I asked him to tell the jury about all that. And Dr. Burt Walls turned to the jury and he said, "Ladies and gentlemen, babies come in small, medium, and large." They loved him. When they came back with a jury verdict for Dr. Walls, and this is the only time this ever happened in my life, the jury asked for the defendant doctor to come back into the jury room. And when he walked in, they gave him a damn standing ovation. Johnny Edwards was beating the shit out of a guy named Gary Valines. He was an emergency room physician. And it was a case, Edwards was representing the estate of a lawyer who'd had a heart attack that he claimed my guy didn't diagnose. And my defense was that the lawyer had been abusing cocaine. That's what caused him to have a heart attack. And Johnny had all his damn charts up and he's cross-examining Valines. And Johnny asked him, he said, "Bob, well, was my client, the lawyer, was he pleasant? Was he courteous?" And Dr. Valines said, "You know, he seemed nice for a lawyer." The jury loved him. The jury loved him. I had two cases with Wade Bird that made some bad law. One of them took 13 years to make the bad law, and that had to do with you have to have court approval before you can do anything involving a minor. That was a case in which Paul Pulley had promised my doc that he wouldn't sue her if she would help him understand the medical record. She helped him understand the medical record, and the son of a bitch sued her. So we went back and forth to the Supreme Court on that a few times, and the end result is you got to have court approval to do anything with a minor these days. That took 13 years. And that was Creech versus Melnick. And then Crocker versus Rothling, y'all all know about, and that wound up a 7-year odyssey. And the bottom line of that is that the trial judge voir dire's the expert on qualifications. After those two cases with Wade, he came up to me and he said, "Sammy, after Creech versus Melnick and Crocker versus Rothling, I promise you I will never ever take another malpractice if the plaintiff's name starts with a C." Along the way, got to make some good law. Jackson versus Baumgardner stood for the proposition that there's no cause of action for wrongful life, and White versus Hunsinger stands for the proposition that an increased chance is not sufficient for proximate cause purposes. And I've got one in the Supreme Court, Robbie and I do, that we just did a brief on, where the issue is whether once a guardian ad litem is appointed for a minor and they bring a lawsuit, does the disability go away never to return, or and do the rules of civil procedure have to be followed? In that case, Chuck Manette took a voluntary dismissal. New lawyers started the case over again 5 years later. And our position is the statute's run on it, and the disability statute giving you to age 19 ain't a statute of limitations, and the disability goes away and you're treated like any other litigant. I hope the Supreme Court will do the right thing on that one. Never celebrate early. Had a case with Bill Moretti. We were defending an oral surgeon in Moore County, and the first week of trial had gone great for Moretti. And the truth of the matter is, we were still trying to figure out what our defense was during the first week of trial. And Friday night, the plaintiff and her husband and Moretti and Cliff Britt had a damn victory party at the Country Club of North Carolina. Well, Moore County ain't that big a county, and word gets around. And damn, somebody on the jury didn't find out that they'd had a celebration at the Country Club of North Carolina. And after the case was over and we had won, the juror told me that they didn't think that was exactly right, and it really pissed them off. Don't celebrate early. My next lesson learned was don't cross the line. I was cross-examining Terry Baker, the plaintiff's expert witness that Richard knows up close and personal. And I was gigging him about being so cozy with Johnny Edwards because he claimed in depositions that Johnny taught him everything he knew about being an expert witness. Well, Baker's slippery as hell, and he was trying to say, no, it really wasn't Johnny, it was his wife Elizabeth, because she was in the news, she had cancer, and it was a very sympathetic thing. And every time I'd try to get him, he would slip away and start talking about it was really Elizabeth. So I got pissed off, and I said, well, let me ask you this. Did Johnny Edwards teach you how to be a good husband? Bam! The gavel came down. Jack Hook said, in chambers. Don't cross the line.
That's 100% exactly how that transcript reads.
Memorable judges, and there have been some. Bob Bell from Charlotte is a wonderful judge, does a great job. And I had a case, and the lawyer on the other side was a fellow named Dove Apfel from Greenbelt, Maryland. And Dove claimed that he was the greatest plaintiff's medical malpractice lawyer, not in just the United States, but in North America. And you can imagine how I reacted to that, and we just locked up like it was ugly. So we walk into court one day, and Bob Bell has taken duct tape and ran it from the bench all the way between the counsel tables. And he said, Thompson, you stay on one side, Apfel, you stay on the other. He got complete control of the case. It was well done. It was good judging. I had a motion for summary judgment on the first day of trial in front of Abe Jones, and it was a case against a plastic surgeon. And Grover McCain had asked for punitive damages, and it wasn't a punitive damage case. So we argued, and Judge Jones went back and said, I'm going to take this under consideration. He came back in and he said, I'm going to deny the motion. I went ballistic. Judge, whoa, you going to mess up this trial. We can't have punitive damages in this case. And Judge Jones looked at me and said, well, if you feel that strongly about it, motion granted. I think the lesson there is object like you mean it. David LaBarre is a judge, Superior Court judge in Durham, and his wife had a med-mal case that we successfully defended. Grover McCain had brought a lawsuit on behalf of the wife. And so I had another case, and Grover was on the other side, and it was in front of Judge LaBarre. And Judge LaBarre had been very active in his wife's case and was not happy with the outcome at all. And so, as politely as I possibly could, I asked him to recuse himself. He said, no, I can be fair. So I walked down the hall to Judge Orlando Hudson's office. He's a senior resident judge over there and a great judge. I said, Judge, will you come down here and hear something? So we gathered in the law library there, and Judge LaBarre's at one end and Judge Hudson's at the other, and Grover's on one side and I'm on the other, and I sort of lay out what the deal is. And Judge Hudson looked at Judge LaBarre and said, what's your position? He said, I can be fair. Judge Hudson said, no, you can't. You're recused. I think persistence pays off is the takeaway. Evelyn Hill, I talked to Judge Ridgway about Evelyn last night. I call her Evelyn Hill. I've never had a judge be as unreasonable and as unfair as Evelyn was in a trial that I had. And she was on my ass from the first moment. And it was really ugly. And so, in closing argument, I made the whole thing about being reasonable and being fair, and talking to the jury about they needed to be reasonable and fair. And I turned my back to Judge Hill, and I said to the jury, even the judge has a duty to be reasonable and fair. And all of a sudden I heard from the bench, objection! The damn jury just smiled. They got it. They knew exactly. They had it. Judge Crow down in Newbern, and I guess this is a lesson about trusting your instincts. Judge Crow had a little bathroom that abutted the jury room, and he sort of let us know that he could sort of tell what was going on in the jury room. And after deliberations for a while in a case, he said, Sammy, you really need to settle this case. And I didn't ask him why. I didn't want to know why he thought that, but he said, this jury's talking about damages. You need to settle this case. And the case could be settled for $75,000, and he leaned on me pretty hard. And I said, Judge, I hear you and I appreciate the advice, but we ain't gonna pay any money. I think we're gonna win this case. Well, we did win the case, thank God. And the lesson there is, if you trust your instincts, you're usually right. You're usually on the money. Pilston Godwin was a judge in Wake County, and he was described by Pooh Bailey, another judge in Wake County, as being the only man that could strut sitting down. We were trying a case at Pilston. It was about 4 o'clock in the afternoon, and Pilston said, and so we come up and approach the bench, and it's a tough case, and it had been a long, tough day. And he said, boys, y'all know what this case needs? I said, no, Your Honor. He said, about 2 fingers of bourbon, we're stopping. The takeaway from that is judges get tired just like lawyers do. And they get to the point where they've had enough. And damn it, it's time to quit for the day. Boo Bailey was a great judge and a great character. And I was trying a case, and the lawyer on the other side was trying to get me to stipulate something. And so he tried to get Boo Bailey involved. And we were up at the bench, and he says, "Judge, Mr. Thompson won't stipulate to this, and this is really important. This is an exhibit I've got to have, and he won't stipulate that it's genuine, and he needs to do that." And Boo Bailey looked at me, and Pooh looked back at the plaintiff's lawyer, and he said, "I think Mr. Thompson just told you to go fuck yourself." I think the lesson from that is that you don't necessarily have to stipulate to anything. I'm trying a case with Johnny Edwards and Cy Grant, a wonderful judge from Ohoski, has been hearing the case. And after about 3 weeks of trial, Johnny sashays into the courtroom and says, "Your Honor, I know we're not going to hold court on Friday, and if you won't hold court on Monday, I've been invited to go to the Middle East for a peace conference, and I'll be able to make that and get back in time for court on Tuesday." Cy Grant never looked up. He said, "Mr. Edwards, if I thought you could do any good in the Middle East, we wouldn't hold court on Monday. But I don't, and we will." All right. Some big picture takeaways. Number one, have fun. Practicing law is hard enough. God knows you got to have fun. I have always told my mid-mal folks that anybody that's got a personalized license plate is probably an asshole. So this is my personalized license plate that my group gave me. EMB DMWAFM. You know what that stands for? Eat more barbecue, drink more wine, attend fewer meetings. You need to have fun. Time flies. You'll be amazed how fast between where you're sitting right there and being standing up here doing what I'm doing goes. It's unbelievable. And so you go from being a young lawyer to having a career before you know it. And so make the most of every day. I define professional success as enjoying what you do, work hard at it, get really good at it, and earn the respect of your peers. And you'll notice I didn't say a word about money. I don't think money is how you define success. I think money is a byproduct, and a byproduct only. You need to be open to new opportunities, whether it's jumping into a case, taking over a case at the last minute, going into a new practice area, or doing something you've never done. Be open to opportunities, because in my experience, that often leads to great challenge, great stress, and great reward. It's important to do that. The most important thing is what happens next. I don't care if you've lost a motion, if a witness has kicked your butt. The most important thing is what happens next. It's just like playing golf. You got to forget about the last shot. It's all about the next shot. And I think that's true in what we do. I will guarantee you that at some point in your career, you will be challenged to do something that you're not comfortable with. And my advice to you is don't do it. Good values and taking the high road is the right way to go, always. The guy today was talking about how to get to yes, and Williams Mullins has got a marketing campaign where they talk about getting to yes, finding yes. I think some of the best lawyering I've ever done is no. Is telling your client what they don't want to hear. Tell them no. You can't do that. Professionalism. I learned back in the 70s the best example of professionalism I want to share with you. Billy Joel had just become a star, and he was going to give a concert at William Neal Reynolds Coliseum, and State College was putting it on, and as State Colleges want to do, they screwed it up, and the damn marketing didn't get done right. And so instead of 10,000 people showing up, maybe a couple of hundred at max. And so Billy Joel comes out and looks around and says, there ain't many of y'all here. Well, he didn't say y'all, hell, he's from Long Island. He said, there ain't many of you guys here. He said, come on down. Y'all come on down. Come on down, get close. He said, I'm going to give you the greatest concert I've ever done. And for 3 hours, he just knocked it right out of the damn park. What a great example of what professionalism is all about. And the smallest case that you ever have, you're going to learn something that you're going to apply in the biggest case you ever have. Work on your weakness, whatever your weakness is. If you're not as good at writing as you want to be, work on it. Whatever it is, work on it. Think about basketball players that are great. There was a time when LeBron and Steph and all those guys, they worked on something they weren't as good at. Maybe the opposite hand from the dominant hand, or free throws, or three-point shooting, whatever it is, they worked on it to get great. Work on any weakness that you've got. Now, in the age of email and instantaneous communication and text and all that stuff that I don't know a damn thing about, I think you have to really, really take time in order to have a thoughtful response. I probably get an email every day that my immediate reaction is, fuck you. I used to have a friend, I still got a friend, but he used to practice Bill Deal in Charlotte. And Bill used to have a bullshit stamp. When he'd get a letter he didn't like, he'd stamp bullshit on it and send it back. You know, that's probably the most thoughtful, not the most thoughtful response that you can make, and it's probably important to think on it overnight. Give as good as you get, but don't get taken advantage of. I don't know about y'all, but the plaintiff's lawyers that piss me off the most are the ones that always want you to be doing the giving and they don't want to give anything back. And don't do it. Don't play that game, but always give as good as you get. And always go to school on and learn from your opponents. Joe McLeod was a terrific trial lawyer and a real street fighter and a tough opponent. And I had Sam Katz, who was the chairman of the Department of Pediatrics at Duke, and a wonderful, wonderful witness, and a great person and a great doctor. And McLeod had him on cross, and Sam Katz absolutely kicked his ass. I mean, it was brutal. He just took him apart. And he did such a great job, I didn't even have any redirect for him. And that's damn unusual. And so the judge excused Dr. Katz, and as he stepped down from the witness box, I look over and Joe McLeod has gotten up and goes over and meets Dr. Katz right in front of the jury and grabs him and shakes his hand and says, "Thank you so much for coming and testifying about this case for this jury." And I'm sitting there thinking, that goddamn son of a bitch has got the jury thinking that he helped him. Brilliant. Prioritize family. Folks, the brutal truth is, we think what we do is really important, but the most important thing in your life is your family. And that is certainly a lesson that I have learned. Another lesson is make time for yourself. I don't consider what we do to be a marathon. I consider it to be a series of sprints. Every trial is a sprint to the finish. And then you got to back away and take some time for yourself. I like to get drunk as shit and listen to loud music. Y'all may have a different plan. But you need some downtime. You need to reload. All right, let's back up and look at the big picture of what we do. Conceptually, I think it's pretty simple. I call it the 3 P's: preparation, persuasion, and protection. And that's what we do. You prepare, you persuade, and you protect your client. And what you're doing is making sure your client gets treated reasonably and fairly. I also think that the more you prepare, the more confidence you have, and the stronger you are. And if you let any of that go down, you don't get as good a result. And it's all about relationships. Lawyers, clients, judges, jurors, staff. It's not about computers, it's not about smartphones, it's not about technology, it's all about relationships. I think it's really important to know your opponent. One of the things that I like to do when I'm dealing with a lawyer that I don't know a lot about is schedule a meeting or some event in his or her natural habitat. I want to see how he or she interacts with the people that he or she manages, that they've got control over. Because if they're an asshole to their paralegal or their secretary, it tells you a hell of a lot about the character of the person you're dealing with. And you learn a lot that way. And the flip side of that is never ever think that your opponent doesn't know you. People know stuff about you that you can't even imagine. And it reminds me of a saying that a boat captain down at Moorhead, his name was Johnny Rose, and this is what he used to say in his high-tider accent: "The night she has eyes." And what he's saying is, people know stuff. People see stuff. You're always being watched. And your opponent's going to know a hell of a lot about you that you don't even know they know. I think you have to develop a stomach for the battle. You can't have a thin skin in what we do. And, but I also think that the happiest lawyers are the ones when they're under the gun and in trial mode. Appreciate what you have always. I've got an office that has got, it's a corner office with a view, and 1 block away is a soup kitchen. And every morning between about 9 and 11 o'clock, there's a line of people that life has kicked to the curb that are in terrible trouble. And I can go over there from my office and look down and see those folks. And it reminds me every day of how damn fortunate I am. And I think it's important to always appreciate what you got. The great thing about being a lawyer is that you can change. You can change your practice. You can change who you practice with. You can change your venue. And that is a wonderful thing that you can do as a lawyer. Not many people can say that. Some in this room have taken advantage of that, and it's a great thing. All right, I got 3 points I'm going to close with. Number one, I encourage you to make every trial a Super Bowl, your Super Bowl. Love the competition, if not your opponent. It's an honor and a privilege not to be taken for granted. It's one of the great things that can happen in your life. I don't think there's anything greater than trying a case against a good lawyer with a good judge. Point number two, if you're not having fun, you ain't doing it right. You gotta have fun. And point number three, which has been my mantra throughout my career, never underestimate the ability of a plaintiff's lawyer to fuck up his or her case. And the corollary to that is give them every opportunity. Thank you.